like to reserve 3 minutes for rebuttal.
Okay, 3 minutes.
Good morning, Your Honors. May it please the court, I'm Nick Pernick out of the Nashville Bar. I represent the mother in this matter. Mr. Michael Cardwell is here. He represents the father, but he has graciously ceded his time to me for oral argument, so I may mention a few minutes of the father, but most of the oral argument is going to be concerning the mother. This case is a termination of parental rights case, and it reminds me of an old 80s hair band song called Round and Round, Here We Go Again. This case went before the trial court. It went up on appeal time number 1. In the middle of that appeal on the briefs, it was remanded back to the trial court to make findings as to one of the grounds, the willingness and ability. Came back up to the appeals court, was briefed, was oral argued, and then it was remanded a second time on the willingness and ability ground, as well as best interest. And that was appealed once again to this court. Basically, we're here, it's narrowed down. You know, there are several grounds for termination of parental rights. We're down to one prong of one ground, the willingness ability ground, as to whether the returning the child would pose a risk of substantial harm to the physical or psychological welfare of the child, whether the court can make that findings. Substantial risk of harm, it's got to be a real hazard or danger more than a theoretical possibility. And in this case, the court in DCS could not find a risk of substantial harm of returning this child to his parents. Remember, in a DCS case, we have a permanency plan. What is the permanency plan designed to do? To remove that risk of harm, to change what brought this child into custody and allow the mother or the father to take control of that child and raise that child. The parents completed the permanency plan to remove the risk of harm. The mother did her assessments, parenting assessment, psychological evaluation. She did domestic violence counseling for 3 years, in 2018, 2019, 2020. She did her mental health counseling. She kept that going all the way through the trial. She did her parenting classes. She got stable housing. She consistently visited with the child. Where's the harm that's going to be severe in returning this child?
Well, you say she got stable housing, but the court made a specific finding she did not have a stable housing. So I guess my question to you would be, could lack of stable housing plus medical disorders that are untreated constitute a substantial harm?
Well, the two things. First, the stable housing. There was only testimony from the mother that she was living at the family shelter at the Salvation Army, and the child could move in there with her. I understand that a homeless shelter is not...
Didn't mother testify it would not be an appropriate environment for a child, though?
She did. She testified that that would be appropriate for the child. The child could stay there. It wasn't
appropriate or
free housing.
inappropriate? Appropriate or inappropriate? I thought mother had indicated that that housing would be inappropriate for the child.
Yeah. The housing part of it?
Yes.
Okay. Salvation Army, it was paid rent. It's a place where children and families were allowed to stay. Now, of course, she was looking for a better place, but that doesn't say that because we're in a homeless, because we're in a shelter, because we're in a place that's supported by the Salvation Army, that is inappropriate for a child. Of course, we want something better, but the goal is not to make these parents perfect. The goal is to put these parents to where they can raise their child. And at the Salvation Army in the shelter, she could raise them. The second part of it was the mental health issue. The court specifically found that the mother was compliant with her mental health in the order. Then again, the court found that the mother had mental health issues, and that was a reason not to give the child back. So there were two opposite findings.
So
there.
what is the medication then that the court is referencing to in the second order? What does that have to do with? Is that not related to her mental health conditions?
Yeah. Medications. So at the time of the trial, the mother was doing therapy and case management. And there was no evidence that the mother needed anything else. DCS had access. In fact, the case manager testified, I have a release of information to Centerstone. And the DCS case manager wasn't concerned about mother rescheduling her appointment sometimes. But there was no evidence put in that the mother needed medication or anything other than what she was getting. It's up to DCS to prove this case. They had access to the records. If she would have been prescribed medication and was not taking it, sure, that would be a risk. But there was no evidence that she was prescribed medication or that she was not following the course of treatment that they had laid out for her.
The mother and child, what kind of relationship did they have
Her relationship,
with the child?
well, her relationship, as you see, the case manager testified that she sought appropriate relationship between both the mother, the father, and the child. There was a little bit of a hint from the Camelot worker that sometimes the dad would be upset at the visitation, but the Camelot case manager said she observed nothing inappropriate with the mother. So they had that relationship. Now DCS argues that at this point, because we've been on appeal for 3 years, that they haven't had a relationship because once parental rights were terminated at trial level, visitation was cut off. The Supreme Court in Re AMH said, we can't consider that. DCS will argue, well, it's focus on the child, but the Supreme Court said, what's going to happen if we consider that length of time this case has been on appeal and that there's been no visitation? What they said was, it'll cause people to go, aha, if I can stretch this case out, the longer I can stretch it out, the better chance I have to win. And that is not an appropriate policy for this court to have. We don't want to stretch these cases out. We want to make finality and get them done as quickly as possible. Now, they don't get done as quickly as possible at the trial court level, but that's an issue of funding, judges, everything else, plus the COVID we had. We looked at the manifest. At one ground, I don't think this court cannot find that there's severe or real hazard danger to returning this child to the mother. Then
There only needs to be a risk of substantial. There only needs to be a risk of substantial harm, right?
Excuse me, Your Honor.
There only needs to be a risk of substantial harm, correct?
Correct. And the risk, but it's got to be substantial or real, not theoretical. Yes, the mother and father could get back together and they could have domestic violence ever again. But the evidence showed that the last domestic violence incident that happened was 3 years prior to the trial. So that becomes a theoretical harm. Same with the other. Mother couldn't afford to take care of the child. Well, the mother had been working all the way through and was working a job at the time of the trial and could afford to pay her rent and take care of the child. The mental health issues, once again, the evidence, what evidence was there? That the mother was doing her mental health treatment. There was no issue of whether she was supposed to be on medication and wasn't, or supposed to be doing something and wasn't. It's just theoretical. The judge has to assume, well, what happened 3 years ago or 4 years ago is what's happened today. And you'll see in the evidence here that the department tries to present and that the judge relied on. This is all, look what happened 4 years ago or 3 years ago before the mother did all her services. And now we're going to bring that back today and say that's an issue. The court moved on to best interest, and this is really concerning, Your Honors. On the best interest side, of the 20 factors, if you go through them, 7 of those were not addressed at all. 6 of them just repeated the statute, and instead of putting whether the parent did this, they put the parents have not, and repeated the statute, no factual support. 3 of them only mentioned the father. Out of 20, a total of 4 factors talked about the mother. That's all the court considered. And one of the factors in that was about visitation, that because the parent had not been allowed to visit since the TPR happened, then that was in the best interest of the child, and that's time-wise. The other three were not supported by the evidence. That the court found that the mother could not take care of herself, much less the child. At the time of trial, she had housing, job, doing treatment, visiting the child, doing everything she needed to do. It was time to return that child to the parent, not time to cut off the ties. The other item on the best interest was whether the child has created a healthy parental attachment. Of course, the child created a healthy parental attachment to the foster parents because of the length of time this thing took. The child also had a healthy attachment to the mother. You can see that in the notes on the visitations, that the mother and child, she fed him, she played with him, she helped him with his homework, she did everything a parent's supposed to do in that short period of time that she had each week or every other week for visitation. DCS is in charge of visitation. The court's in charge of it. She should have been given more, but in the time she had, she demonstrated what she needed to do. Finally, the question is, at the time of trial, has a parent done a lasting change of circumstances? The court stated the mother did not have available housing and still struggles with mental health, medical, and domestic violence. None of those are factually supported. The housing, yes, Salvation Army is not the best, but it's where a family can stay and she can raise them until she gets better housing. There's an issue, but it's not a safety issue, it's not a risk. The medical issues, I don't know where that came from. I don't see it in the evidence at all. The mental health issues, the court found about medication that was not in the evidence. The mother was treating her mental health issues.
Counsel, was mother skipping multiple therapy sessions, though, in terms of, you said she was going to counseling?
She had missed some therapy sessions. Now, the Centerstone, the DCS case manager remembered that she may have missed 8 to 10 therapy sessions altogether. But we didn't get into evidence how many did the mother make. The mother did testify, yes, when I missed them, I rescheduled them. So if you miss one on Tuesday but make it up on Thursday, is that really missing a session? No, because you're supposed to go once a week. Instead of Tuesday, you canceled that one and you went on Thursday. DCS could have put into the evidence saying, okay, the mother was supposed to make 20 and she only made 7 of them. Instead, they didn't. They said, well, she missed some. Well, we don't know if she made 20 or made 20. The court also found, based upon the testimony, I guess this goes to credibility, that the mother was compliant with her mental health. So it's hard for this court to go, on the one hand, she's compliant, on the other hand, she's got mental health needs.
Okay,
You'll
your
have
time
to
is,
sift through the record and see what.
your time is up.
Oh, I apologize, Your Honor.
It's okay.
I didn't look at the red light.
Thank you.
Excuse me. Good morning, Your Honors. May it please the Court, Catherine Adams for the Department of Children's Services. As stated by appellants, this is a termination of parental rights case regarding the child Dakari. Dakari was removed from mother and father's custody in November of 2016 when he was 2 years old. Dakari has been in DCS custody and in the same foster home since that removal, and he is currently 11 years old. As appellants have stated, this case was sent back to the trial court on limited remand for additional findings for the substantial harm prong of the failure to manifest ground. And the trial court did make additional findings from the initial order for the first appeal in this case. The trial court on pages 9 and 10 of the second amended final order makes multiple paragraphs of additions to its findings. These include findings regarding both parents' unstable housing, lack of employment for father, criminal history and incarceration, and the risk of psychological harm to Dakari in being returned. Expanding on those findings, as questioned with opposing counsel, the question with substantial harm is whether there's a risk of substantial harm to the child. And here, there are multiple reasons why there would be a risk of substantial harm to the child if he were returned to parents' custody. First, there's a risk of physical harm to Dakari due to parents' lack of appropriate housing and income. At trial, father was living in a hotel paid for by mother for the week. He had lived in multiple locations in the month before trial and admitted to sleeping in his car on occasion. He had no income and had not provided any financial support for Dakari in the approximately 5 years between Dakari's removal and the trial date. Mother also did not have safe housing. She was living at the Salvation Army and using her limited income to support father, who
But
she
the
admitted.
Salvation Army did allow children there, right?
It did, Your Honor. Mother's testimony was very inconsistent on whether Salvation Army could be housing for Dakari. At some point, she said people did live there with their children, but then when asked point blank if she had housing for Dakari, she stated she did not. Ultimately, the trial court found that the Salvation Army was not stable housing. And that finding, there's no preponderance against that finding. In the record.
There's a lot missing to me in the court's second amended order here. We know that there's a step sibling involved here and a severe abuse of finding, although both parents here were not named perpetrators in that case. But, you know, I'm struck by the fact that there is no finding that either parent proposes a risk because they could not protect this child from severe abuse, despite no finding of perpetrator. I'm also struck by the fact that, at least with respect to the mother, there's mention of mental illness diagnoses, but no indication of the severity of any of them. I mean, so there's PTSD, OCD, and there's a third one I can't recall now. But we don't know anything about the extent of any of those mental illnesses, do we?
Well, Your Honor, I think, to begin with, I do believe there are sections of this order that could be clearer. I think the entire order does make additional findings from the first order. I think as to the mother's mental health diagnoses, I think one thing that does come into play is the trial court's finding on the domestic violence issues that are continuing, and that mother is unable to extricate herself from father, which are findings in the final order. And I think that while there's not explicit findings on the severity of her specific OCD diagnosis and things, there are findings that relate to mother's inability to extricate herself from father and how that would negatively impact
When was
the
the
child
last
and their
domestic
relationship.
violence incident?
Well, so mother testified the last domestic violence incident between her and father was in 2018. She had admitted there had been previous charges brought between them. I'm not sure the exact date of those. Father did have pending domestic violence charges at trial with another individual, not with mother, but with a mother of another one of his children. And the testimony of mother and father regarding their relationship is concerning in itself, because father testified they were in a relationship and were spending time together, and that mother was his caretaker, and mother testified she did not have a relationship with him, but admitted she was paying for his medication, paying for his housing, and all of these things, which showed they clearly were still interacting.
So should
and
we
still leaning on each other.
should we presume then from all that that the trial court credited father's testimony then on the nature of the relationship with the mother?
I'm not sure it's implicitly a credibility finding on father's testimony. Mother herself admitted that she was paying for all of these things, so she admitted a certain level of entanglement. I don't know that the trial court said, yes, y'all are in a romantic relationship still or not, but mother herself admitted that she was still supporting father, and also mother stated that that there were concerns given father's testimony because she didn't see that's how the relationship was, even though father said he was going to marry her.
But when it came down to determine exactly what the risk of substantial harm was in this instance, the court really didn't focus on the potential for future domestic violence, but rather instability in housing, untreated mental illness, and then the fact that the child is virtually strangers to his parents. Although, again, that is troubling for me because of the length of time this has been pending. And of course, after the first order terminating parental rights, there would not have been any contact. The parents had no control over that.
Yes, Your Honor. I think as far as the risk of harm to Dakari if returned due to his relationship with foster parents or lack of relationship with parents, I think it's important to note that Dakari himself testified at trial. At 8 years old, he gave very comprehensive testimony that he did not want to live with parents. He wanted to live with foster parents because they made him feel safe, and parents did not make him feel safe. And that was 3 years ago when parents were regularly visiting. Parents had seen him the month before trial, and he still did not want to live with them. He wanted to live with foster parents. So respectfully, I don't think it's just that it's been 3 years since the last visit that means why Dakari would be psychologically harmed if he were to return to parents' custody. I think there's other things that contribute to that, including parents' negative interactions during visits. The Camelot worker at trial testified not just once, but a couple of times about different incidents of
But did
aggressive
those mostly
interactions.
involve the father, not the mother?
A lot of it was focused on the father, but Camelot worker also did discuss that both parents didn't seem to respect Dakari's wishes. They would do things that made him uncomfortable, like sing songs that made him uncomfortable and things. While a lot of the aggression was more from father's perspective, there still was evidence that both parents didn't necessarily use visitation to make that positive relationship, especially given those instances of making Dakari uncomfortable, and considering Dakari's view of parents and how they wouldn't be able to keep him safe. And I think opposing counsel discusses the best interest factors and the best interest findings. The trial court did expand on the findings made in the initial order. The trial court previously addressed only 7 best interest factors. The second amended order has 13 sections that address 11 factors, and overall concludes that best interest factors support termination. Briefly, DCS did make reasonable efforts to assist the parents in this case, yet parents did not reciprocate those efforts and had not improved their circumstances at trial. At trial, neither has suitable housing, as discussed. Father had no income, and outside of the stable housing and income issues, they were not consistently treating those mental health diagnoses. Mother did miss about 8 to 10 therapy appointments in the 6 months prior to trial, so not in a long period of time.
Did she make those up?
That's not clear in the record, Your Honor.
Okay.
And also, as stated, they had not resolved those domestic violence issues. I also believe the abuse of Dakari's half-sister weighs heavily in favor of termination. Her medical records are in the record, I believe, is Exhibit 18. I won't go through all of her injuries, but at trial, mother still did not have custody of that child, and she was still enjoined from seeing her. And father testified that he had 8 other children, but only had custody of 1 at trial, and that child was the child whose mother had pending domestic violence charges against him. So it's not clear that parents are able to care for any other child, much less Dakari. As stated, parents did not use visitation to foster a positive relationship. Dakari was often uncomfortable. He gave his explicit testimony as to his preference of who he'd like to live with. And this is in direct contrast with his foster home. As stated, Dakari has been in the same foster home for almost 9 years. He's thriving there. He has emotionally significant relationships with his foster parents and with his 2 foster siblings, who he calls his brothers. He is loved in this home, a home which provides him safety and stability that parents have proven unable or unwilling to provide.
Why, I know the litigation took 3 years, but Dakari was taken when he was 2, right?
Yes, Your Honor.
And so between ages 2 and 8 or so, what was going on?
DCS was working services with parents. Parents were attempting to resolve their circumstances. Father actually testified at trial that the time between trial and the date that Dakari was taken was not enough time for him to get things together. Those are his words. As to the exact date the petition was filed and why that was chosen, that's unclear from the record.
Didn't mother in this case also have to resolve some criminal charges during this time period?
Yes, Your Honor, and she did. There's no testimony in the record that mother had pending charges. She had been incarcerated for, I think, a little less than a year during the custodial episode, and that had resolved whatever pending charges she had at the initial moment. So she did resolve that.
Yeah. Still,
issue.
we have 5 or 6 years, and that's a long time. When, at least from the cases we see, that's a very long time.
Well, and Your Honor, I believe that was time in which the parents could have
They were
addressed
working on
their
it.
unstable housing and their income and domestic violence issues and kind of all the things that are preventing Dakari's return to their custody then and at this point. So DCS would ask that this court affirm the trial court's order, and I'm happy to answer any more questions with my remaining time.
No other questions? Thank you.
DCS discussed, or the Attorney General discussed, the reasonable efforts. One of the things, I'm not sure how many case managers we went through on this case. I was not there at trial. The last case manager actually testified had only been on the case for 6 months. That's at the time of the trial. But the testimony was consistent. The mother said, "What do you need me to do?" One time she told us, DCS said, "We need you to take care of this criminal charge. We need you to get done." Now the mother at that point had rented a 3-bedroom house, ready for Dakari to return, but they said, "You need to get this criminal stuff over and done with." Mother turned herself in. She paid for her rent all the way up through the time she was going to get out of jail, so that she'd have that place as soon as she got out and could clear the slate. So she did that. Then unfortunately, if you recall, back in 2020, we had a few tornadoes hit Nashville, and that destroyed the house that she had planned to. And that's what put her in the Salvation Army. Which goes to show that instead of moving back in with Dad, instead of resuming that relationship, she chose to do something on her own. Yes, she helped him throughout the time, because he's Dakari's father. Yes, there was at least a relationship as far as her assisting him, but the evidence clearly shows she took herself away from him as far as living with him, the romantic relationship. She was on her own trying to get Dakari back. The second part is just this order, as the Attorney General pointed out. This is the second amended final order. These things need to come to finality. And the reason why we have a second amended final order is the evidence just wasn't there to terminate parental rights. You can comb through it, and what you have to do is dig back to what happened in 2018 and say, well, that must be the situation today, and make the assumption that what happened then, that the mother didn't do all the services, that she didn't get her own housing, that she didn't move on, that she didn't work to get her child back, and then say, well, whatever happened when these kids when this child came into custody continues to happen today. So the evidence has to fail. The other issue is, can this child be safely returned to his parent? Yes. We may have a time of transition here. DCS snatches kids away from their parents and put them into foster home without any warning, limiting visitation or cutting it off altogether. The opposite, we have a chance to make that happen in a slower, more methodical fashion, but we can return the child to this parent, and because DCS was unable to prove that there were grounds in best interest for termination of parental rights, that's what should be done.
Thank you very much. Thank you both. Would you call the next case, please?